There, now maybe you can see us. Can you see us?
All right. Hello, everyone.
Okay. All right, this is Whitney Washburn, our guest speaker today.
Well, good evening to all of you. Can you hear me okay?
Yes.
All right. And how many people are in the classroom?
About 20.
Okay.
They have a holiday tomorrow, so these people are here just for you. Normally they skip, a lot of them skip class, but not these ones.
Okay. Well, Matt asked me if I would speak to you, and I understand that you're enrolled at California State University Maritime. And I understand that this is a law class, and he indicated, I guess the title of the class is History, Study, and Practice of Maritime Law. Is that right?
Yes.
And you're in the practice portion right now?
Yes, sir.
I don't know anything about maritime law, so I can't speak to that at all, but what Matt asked me to tell you about is my experience with solo practice. In my practice, I went from being with Sacramento's largest firm, which is Downey Brand Seymour, to a partnership with one other fellow, and then that lasted a number of years, and then I've been on my own since 2002. So in kind of a nutshell, that's me. Let me tell you a little bit about my practice area, and then I'll take just a few minutes and tell you what my experience has been, and then Matt suggested that I open it up to questions, and you can ask me anything you want about what I do. I am a civil litigator. That means that I practice civil law in the courts, the federal and state courts in California. Occasionally some matters out of state, but it's almost all been in the state of California. I started practicing in 1982, and soon after graduation, I went to Pepperdine School of Law down in Malibu. Soon after graduation, I joined the Downey Brand firm in Sacramento and was there 11 or 12 years and was a partner in that firm. And I did the same thing that I'm doing now, which is civil litigation. And it was a great experience to be with a big, well-established firm. I don't know how many lawyers Downey Brand has now. I think it's probably in the 100 to 150 range. A terrific experience, lots of good training. They have good procedures in place. They teach you how to do things and what not to do. And so that was a valuable experience. In 1996, another partner and I started having some private discussions about leaving Downey. We both wanted to be on our own. It wasn't that we didn't like Downey, but we just really wanted to have our own firm and continue doing the same thing. And he was also a civil litigator. So this other partner and I, Peter Glick, finally made the decision to leave. It was for us, that was a pretty scary decision. We both had young children, we had mortgages, and we didn't know what to expect. So in 1996, we went out on our own. We basically were able to carry ourselves without incurring any debt. We got the practice up and running, and things went fine. And Peter and I had our partnership for about 6 years, and then in 2002 he went solo and I also went solo. And my practice is, it's always been located on the east side of Sacramento. I'm in Folsom. I don't know if you know where Folsom is, but I have an office there. And I've been in the current space that I'm in about 4 or 5 years. My arrangement has always been to sublease space from other people, and that's worked out really well. Peter and I did that when we left Downey Brand, and I've been doing that ever since. So 2002 until today, that's basically 15 years, and I can tell you, although I appreciated and enjoyed most of my experience at Downey Brand, I haven't looked back once at going back to the big firm. For me personally, I really like being on my own. And I like being able to make decisions about what I do, what I'm going to do, and I don't have to answer to anybody. And that has been a real plus for me. It's not for everybody. There are some definite downsides to it. Vacations can be a little tough because you don't have a team that you can turn to and have them pick up the slack while you're gone. Managing employees can be a challenge at times. I've had as many as 2 or 3 people working for me, not attorneys, but other staff people. Right now I have only one, and that is my wife. She's basically a paralegal slash administrative assistant, and she works for me. I would say it's on a part-time basis, not a full-time thing, and that's worked out really well. And in the last, because I've been practicing so long now, I've scaled my practice back a bit, and that's allowed me the luxury of not having any other employees. In terms of what I do day to day, so that you can see kind of how my practice style fits in with what I do professionally. As a civil litigator, I specialize in business litigation and real estate and trust and probate litigation. It's pretty much all litigation. Once in a while, a business client will ask me to handle a transactional matter. I don't do a lot of that. By transactional matter, I mean things such as preparing leases, preparing agreements, things like that. So most of what I do is getting cases ready for trial and trying them. I've done a fair amount of trust litigation. There's a lot of that in California right now, meaning that beneficiaries or hopeful beneficiaries of a trust will sue the trustees of a trust, claiming that somehow something went wrong in the administration of the trust or that they were excluded from the trust. So I've done a fair amount of that kind of litigation. Typically, and let me get my, if you can bear with me a moment, I need to make sure that my charger is connected here. Typically, on the business side, I represent smaller businesses. They generally are locally based, and I will represent businesses in contract disputes, things like that. So that's kind of what I do, and I enjoy the work that I do. In my opinion, it's the cream of all the litigation work. I don't do any family law. I don't do any criminal, things like that. So I really enjoy that kind of work. In terms of library, all of my library is online. I subscribe to, there are basically 2 big services out there, Westlaw and Lexis. I subscribe to Westlaw. It's a terrific product, and I have basically everything online that I want. I have digitized my office. Essentially everything that comes in the door now by snail mail is digitized. Everything that we send out is digitized. We have shredded nearly all of our files. We keep a short, in terms of hard copies, a short retention period, maybe a few months, but we shred everything. And we have a good backup system so that if we had a computer crash, we wouldn't lose all of our documents. That was a little scary going digital, but it's been a good move. I work from a laptop, which means that I have basically my office with me wherever I go. So that's been terrific, and I've really enjoyed that. Let me mention just a little bit about referral sources. I have some notes here, and I want to make sure that I've covered the things that I thought you might be interested or maybe not in hearing. Referral sources are always an issue for attorneys. I've never advertised. My referrals come either from other attorneys or from CPAs or from clients, and that's been the pattern ever since I started practicing, and that's been nice. I've rarely wanted for work, and that's been good. If you've been practicing as long as I have in Sacramento, you get to know people, and that's, people will refer me to, they'll refer their contacts to me. And then one last thing I wanted to mention is, in terms of having my kind of a civil litigation practice, often I'm involved in cases that require more than one person. And so it's been my practice right from the get-go on a case of any size. I will get the client's permission right up front to associate in co-counsel. And so often I'll ask another attorney, another litigator that I know, and there's a handful of them that I'll bring in to actually be co-counsel with me. And both of our names will appear on the court pleadings. We will we'll share the work. We try not to duplicate, and there's perhaps some duplication at times, but we try to keep that to a minimum. But on a case with any complexity and that is of any magnitude at all, you're going to have a need for co-counsel, and so that's been a real blessing. It also allows me to balance and juggle my other caseload and also vacation and time off, things like that. So that's who I am and a little bit about my experience. Matt, anything that you want to add, and any questions from anyone?
Yeah, we'll definitely have some questions. First of all, did you say how long you were at Downey?
I was at Downey 11 or 12 years.
11 or 12 years. So by then you were definitely responsible for making rain, bringing in clients.
Sure.
Yeah. And when you decided to leave, could you bring some clients with you?
We did take some clients.
Uh-huh.
The kind of the rule of thumb is that a departing attorney can tell clients of the firm that he or she is leaving. They can't disparage the firm they're leaving. I mean, if you do, you're kind of shooting yourself in the foot. I've litigated issues like that before. So yes, we did tell some clients that Peter and I told some clients we were working with at the time. We said, hey, we're leaving. We're opening our own shop. If you would like us to do any work for you, we'd be happy to do it. And we did take a handful of clients.
Yeah, well, the reason I ask is you said you had a mortgage and it was risky and nerve-wracking. I mean, it really all depends upon whether you can make a living on your own or not, and that has to do with whether you have clients or not. So you could just start completely fresh and hope that someone comes along, or you can kind of have a little security blanket, but at some point you have to develop your own anyway, right?
Sure. It would be really scary, I think, to get out of law school and hang up your own shingle and not have a client base to go with you. I think that would be a pretty scary thing. I've had some younger attorneys that I've become friends with that have done that, and that would take a lot of guts. I think that would be a lot harder than what Peter and I did.
Okay, and then on the issue of associating counsel, a few weeks ago we had kind of a senior attorney who discussed that from the other side. He's actually sort of turned his practice into being the person that you associate, because he's an expert in certain areas, and he's made a reputation where younger attorneys who get clients that maybe they aren't in an area they're not necessarily expert, they will associate him, and he takes a piece of the fee and brings the expertise. But that sounds like a different version of associating. You're saying it's just the quantity of caseload, or why do you associate another attorney?
If a lot of the cases that I'm involved with generate enough work that one person can't do it all. Or if I did do it all, I'd have to basically set aside everything else, and I can't really afford to do that. And I think two heads are way better than one. I'm really convinced that there is a real power in collaboration, in sitting down with somebody that's completely up to speed on the case, kicking ideas around and strategies, and you come up with a better product than I ever could do on my own. I'm an absolute believer in that idea.
So it's
there's some synergy there that I think really kicks in.
So it's a synergy thing and a quantity of work. It's not necessarily an expertise.
Right. Yeah. In fact, that's actually the closest I would come to bringing somebody in on expertise is on the trust matters that I litigate. I am not a probate attorney. Probate attorneys handle, regular probates and trusts, and they usually don't handle litigation relating to them. So on the trust matters that I've handled, I generally will have a probate attorney, usually the one that referred the case to me, stay on as co-counsel. That way they can handle all the probate procedural stuff that I don't know how to do very well, and then I do the litigation side, the depositions and the discovery and getting it ready for trial.
A little quid pro quo, keep them on.
Yeah.
Okay.
Yeah, really.
Who else? You got one back here?
So is that a common practice? So if you're leaving like a big law firm, is it common to see if you can bring some clients with you?
I'd say absolutely yes. Let me tell you about an experience that I had at Downey Brand as a young attorney. I think I had been at Downey about 6 months. One day I came into the office and there was an armed guard at the door. Actually, he wasn't armed. I take that back. But he was a guard. He was wearing, the uniform and the patch and all that stuff. And so I went in and asked what was going on. And 5 or 6 of the attorneys in the firm had decided to leave, and they were kind of keeping it under wraps, and somehow word leaked out, and the partners at Downey Brand decided that they wanted to basically do everything they could to protect the clients that the firm had, and so they posted this guy at the door, and then later on in the day I saw a big shouting match. It was great. It was like out of a movie, and these guys are yelling at each other, the guys that were leaving and some of the other guys. So they really got into a tug of war about what was going to happen with the clients. But ultimately, it's up to the client. Anybody can make a pitch to the client, but the client has to decide. But yeah, that's really typical that a departing attorney or group of attorneys will do whatever they can to take clients with them. Clients are everything.
So this is good. It's actually something we were going to talk about after signing off, but if you don't mind hanging on a little bit, I'd like you to be involved in the discussion. Something we were already going to talk about today, which is the progress from being a brand new associate in a firm to becoming a partner, and what that takes. And then this is sort of what we've been talking about here now is sort of the PS or the after to that. So the general rule is, as an associate, you learn the ropes, become known, that you can do good work, and as you get older, you're expected to bring in clients. Not older, but as you get more experienced in the firm, you're expected to bring in clients and quote unquote carry your own weight. In fact, I remember when I was working at a firm, the term was eat what you kill, which is a little graphic, but the point is that you can bring them in, and they're your clients, you make the money, you work with them. But tell me if you concur with this, but in order to make a partner, in order to get that senior status, you really have to get to a point where you could be self-sufficient. You're carrying your own weight, and they're not doing you any favors. You're sort of doing them a favor by bringing your client. And thus, therein lies a little bit of a conundrum, because if you could be on your own, why not be on your own like him? And why not stay with the firm and use the resources of a firm, but also lend them what you've brought? You with me on that? Does that make sense? Is that your experience? Was that your experience?
It is. Sure. As you become more experienced as an attorney and progress toward partnership, and most partnership tracks nowadays are 8 or 9 years, you do develop your own client base, and you start to, in some cases, you will control clients. But there's kind of I guess you think of it as a continuum. There are the attorneys that are kind of the workhorses, that they don't have a lot they don't have a big client base, but they get a lot of work done, and they're good to have in the firm. Those kind of attorneys can make a partner, but maybe not as fast as the guys kind of at the other end of the spectrum, who are kind of the rainmakers, the guys that will control huge book business. And so you kind of got that continuum. I've seen people all along that continuum make partner, but it is easier for the rainmakers. Sometimes the rainmakers will actually, like, say the person is a senior associate. That senior associate, if he or she has a really big book of business, they can use that to leverage themselves into a partnership position. They can go and they can say, hey, look, normally it would be 2 more years for me to be partner. I'm not interested in sticking around 2 more years as an associate. I want to become a partner, and I want you to do it now. So they can kind of leverage that, and that can work. Some people stay on with the big firm, even though they control a big book of business, because they want the prestige of a big firm. They want that big firm name behind them. I think about one guy that joined Downey after I did. He had a real knack for being a rainmaker, and had controlled a huge book of business, and he's now the top earner at the firm, and he's done really, really well. He opted not to leave. He probably could have made more money if he left, but they're compensating him really well because he's essentially threatened to leave even after he made partner. Another thing that Matt said that triggered a thought is, when you're with a big firm, the overhead can be tremendous. I was talking to a friend of mine he's about my vintage. He's with one of the national firms that has a satellite office in Sacramento, and he was telling me that his overhead, the overhead that is allocated to him, is about $200,000 in that firm. And so I assume that would mean that every attorney working in that particular firm, they've allocated an overhead of about $200,000, which is incredible. I mean, a lot of attorneys don't make $200,000, period. So he's got to earn $200,000 plus to even get to the point where he's positive. And I just don't have that. I have really low overhead, and to me that's a real plus. I do have overhead. It's nothing to sneeze at. I have malpractice insurance and rent and library and other expenses, but it's not even anything remotely approaching what it is in that big firm.
So you have to be the rainmaker and the workhorse.
Yeah, I'm everything. My wife as assistant, she does a lot of stuff for me, but it's not a situation where she's going to go out and develop business for me or things like that. I'm really doing it all, and frankly, I love it. It's been great.
Other questions?
Like, though, it ain't for everybody. Is there a comment?
We may have another question. Anybody? Nope.
I had a question.
Okay.
How was you said you went to Pepperdine? I wanted to ask, how did you like that school?
Oh, I loved it.
Yeah, because it's in the West Coast.
I assume some of you have been to the Malibu campus.
Yeah.
It's a great place. It's a good school. I had during the 3 years that I was there, I was part of a study group that we had a desk that seated all 4 of us, and it was looking out. We had a great view of the ocean. We could almost see toward Santa Monica in one direction, and then Point Doom out in the other direction, and it was great. So just from the physical facilities and location standpoint, terrific campus, good law school. They had Ken Starr there as the dean after I left. They've got good faculty, good school.
I was gonna say, has it become a bit of a distraction being at such a gorgeous campus?
Well, maybe a little more the second or third year. The first year, I was so scared I didn't even look up. The stuff you hear about the first year of law school was really true. And I remember, and I'm sure Matt has stories like this too. I remember at the end of the first year when we knew that this one particular morning they were going to post grades. And so the students are all milling around the board where they're going to post them. But this was before stuff was online, because this would have been like 1980 or 1979. So we all are milling around there, and there's one guy down there, when they finally posted him, he's just got tears running down his face because he didn't make it. He got washed out. But yeah, it's really scary that first year. but it's also exhilarating.
Yeah, I had a question. I was just wondering, a lot of times when you go into business, whether that's creating your own firm or any other business, you know, it's difficult to come out on top and make a profit. So going into business the way you have, has that been difficult? Is it hard to make a profit the way you do your business?
No, the model is really simple, and from a business standpoint, it's a great model. I have, in comparison to my income, I have really low overhead, and so I don't have to generate a ton of money to have a comfortable living. And from the very first month that we were open, Peter and I turned a profit. It wasn't a big profit at first, but it was enough to live on, and it went up. Now, it hasn't gone up every year since then. It's kind of, roller coaster some, but there has never been a year that we haven't been able to live pretty good. And would I have made more money if I stayed at Downey? I think I would have, but I don't think it would be a ton more. And I don't have the commute to downtown. I don't have to have a whole bunch of other partners to answer to. So for me, it was great. Oh, I should mention, I'm not positive. I have my phone plugged in, but I'm not positive it's charging. If this call ends all of a sudden, you'll know why, and I'll boot my phone back up.
Okay. Well, I think we're drawing to a close. We have one more question in the back.
How much have you seen what college somebody came from or what law school they came from influence their career? How many opportunities do you think it opens up based on where you came from?
So I had a little trouble hearing, but I think the question was what's been my experience in what I've seen as far as the school that someone attends influencing their career?
Yep.
Yes.
Okay, that's a really interesting question. We had a guy at Downey that, if you on a resume, he should have been absolute killer. He graduated from Harvard. He had other credentials. He just should have been killer, and he did not do too well. And it wasn't because he wasn't bright. He really was really bright, but there were some other issues in his personality and kind of the way he did his work and things that really made life difficult for him. I think once somebody gets established, I don't think the school makes all that much difference, with one caveat, and that is that so long as they went to at least a middle tier ABA accredited school. I've got a friend who went to Lincoln Law School in Sacramento. It's not ABA accredited. In fact, I don't know that it's accredited by anybody. Do you know anything about it, Matt?
Yeah, I've seen the signs and I've heard about it. It's definitely, you're like Heald Business College for lawyers.
And it's a night school, I think, only. I think that the fact that he graduated from Lincoln has kind of dogged him. I mean, other attorneys know that, and they don't forget it, and it kind of makes you feel sorry for the guy. But I think that it's been a little bit of a problem for him. But as long as you're not going to that kind of a school, I don't think it matters. There are plenty of good middle tier law schools. Would you agree with that, Matt?
I would agree with that. Yes. The only thing I would add is that that there is a place for Lincoln Law School if you're just like interested in the law for something you want to know about. Not that you're going to go out and kill at a firm. If you just if my mom wanted to take some law classes because it was interesting, that might be a great place to do it.
I would have one other thought too. A lot of the big law firms, the national firms, they place great weight on the law school. But that wasn't true at Downey Brand. Even though Downey is the largest firm in Sacramento, it just wasn't the case there. So I don't know if I'd gone to, say, an O'Melveny Myers or, one of the mega firms and applied, I don't know that I would have gotten in from Pepperdine unless I was right at the top of my class. So I think that's one area where the law school name does make a difference.
Okay, one more.
So how long between your undergrad and going into law school? Did you
going right away, or did you take some time off?
I worked a year, moved to LA, worked a year for a business down there, kind of a marketing firm. I was doing marketing, but they sold chemicals, and then got into Pepperdine.
Okay, well, before we cut off, I'd like to, if with your permission, let them know how we know each other.
Go for it, buddy.
Do you happen to have a guitar nearby?
I do.
Whit is a fantastic bluegrass musician, and we know each other through a mutual friend and through the bluegrass community, once again. And he's a great singer and guitar player. You play mandolin as well, right?
A little.
Yeah, and
Not nearly like you do, though.
And he has a lot of family members that play, and we camp next to each other every year at the big festival. So would you strum a song or pick a tune or something for us real quick?
Let me go grab it.
Okay.
Yeah, we'll see what happens.
Okay. I should have brought my mandolin. We could have a virtual jam.
We could have. So do your students know about your secret life?
Yeah. Oh, yeah. Sure. I don't hide it. Yeah. No. They always hear about. Anytime anything ever happened in 1945 or 46, I always go crazy. Oh, the bluegrass started. Yeah, they know. Sure.
It's out of tune, but this is not the one I normally play. You know the name, Matt?
What's that?
Is that, you know, the name?
Is that Carter Blues? Is that Carter's
What's
Blues?
that? That was Watson Blues.
Oh, Watson Blues, right. I thought it was Carter's Blues.
And I'm sure you can name the two guys that wrote it.
Bill Monroe and Doc Watson?
You got it, buddy.
All right, I won. All right, great. Well, hey, Whit, thank you so much for your time. We really appreciate it. And we'll let you go.
You bet. Good luck to all of you.
All right. Thank you.